So Vincent, in his introduction of my work, noted that I often engage on the policy side of things, whether it's TPP and otherwise. And consistent with that, I wanted to talk a bit about cyber surveillance from a policy perspective, because in many respects, it seems to me that we are at a potential inflection point, particularly here in Canada right now. We had 10 years, obviously, of conservative government that provided a particular perspective on surveillance and its perspective on what, if anything, some of the Snowden revelations meant. And we fairly recently, of course, just went through a national election in which surveillance and privacy was not a top issue, but nevertheless C-51 and its aftermath certainly provided some amount of attention from any number of political parties. And the government has made it clear that they are open to revisiting both that legislation and, even more likely than just that, revisiting the issue of how we balance privacy and security, and indeed, perhaps, as I'll talk about, how we balance security and security. And so we'll get into that in just a few moments. Now, of course, all of this seems to start in the minds, I think, of many with Edward Snowden. And of course, surveillance doesn't start with Snowden, but I think the public awareness and the realization of the extent to which surveillance activities take place, and that steady stream of revelations that came out of Snowden, both, I think, at first had the ability to shock, and later really left people, I think, in some ways rather numb to all of this, with being almost the inability to shock, given how much we had learned. And so the shocks have come, I think, less from Snowden revelations and more from events where, for example, of course, in Ottawa, just a number of blocks from my own office, we had the attack on Parliament Hill that succeeded almost instantly in shifting much of the debate in our country from what had been a gradual shift to concern over the surveillance revelations that we'd seen to concerns even more about security and how to best address them, which of course then led to Bill C-51, which I think for the first time in many years provided those concerned with privacy and security issues with a very simple thing to say. Simply C-51 had enough mind share in the minds of many Canadians that they at least had begun to think about where it is appropriate to strike that balance and how to address some of those issues. Just as we were moving in another direction, perhaps, to rethink, we had the Paris attacks, which again challenged some of the notions as people began to rethink. And then most recently, out of that, we've seen much debate around encryption-related issues. First, directly out of Paris and the discussion about the use of encryption, and then, of course, more recently, and I think the issue that is going to, in some ways, surpass Snowden in public mind share, that question around Apple and whether or not it can be compelled to assist the U.S. government by creating a software program that might allow it to access otherwise encrypted data, is something that I think is very easy for people to understand, not necessarily all the detailed specifics, but that general notion of the protection of their information, even if they don't quite understand everything about encryption or what Apple is being asked to do. They can understand, I think, in many instances, both the compelling, sometimes, arguments from government about the need to be able to access this information, but at the same time, I think the very compelling arguments that come from technology companies about the inability of math to ensure that only the good guys gain access to backdoors or some of these mechanisms, and the fact that if the good guys can get it, so too in some instances can the bad guys. And so those challenges, and we'll talk a bit more about it in a few minutes, is something that I think will generate considerable public debate, and it seems likely this is the sort of case that, and the cases that may work their way up through the courts and lead to, I think, a pretty robust discussion. And in fact, for anyone that watched John Oliver over the weekend, you know that he covered this particular issue, making it probably more accessible than certainly I ever could. But one of the things that was most instructive was to see a clip of one Senator, Lindsey Graham, who is seen as very strong on security, start the segment by pointing out how surely this is really simple. Just provide law enforcement with the access, and then concluding just a matter of weeks later by Graham acknowledging to the U.S. Attorney General that, in fact, it wasn't so simple after all. and that his mind had begun to shift. And so that kind of debate, I think, is going to play out for many for quite some time. Now, as I say, back to Snowden in a sense, those revelations, I think, woke up many, of course, starting in the United States with the collection of information by the NSA through Verizon, the data mining activities and the PRISM programs, the kinds of things that became household names. And it seemed like each time you were ready to say, well, it stops here and doesn't go any further, there would be new revelations and you'd find out that, in fact, it would go further. Now, in Canada, at least initially, there were some that felt some amount of security, that's in the sense that not security in the sense of feeling secure, but felt better about perhaps this was a US problem. This was the NSA engaged in this activity. Surely our government and our agencies wouldn't be doing quite the same sorts of things, but we have, of course, learned in the months that followed that we not only actively engage, but in many instances are a very willing and very active participant in many of these activities as part of the Five Eyes Coalition. So we know, for example, data collection programs that received the go-ahead from the ministers at the time, Peter MacKay, that date back many, many years, that provided broad coverage and broad acceptability under a ministerial authorization, particularly around the issue of metadata. We, of course, know that spies are going to spy, and we've learned that we spy as well, sometimes for national security purposes, but sometimes it would seem also for economic purposes, something that seems to sometimes fall outside the strict statutory mandate. We know that we play active roles even in that sorts of spying that has taken place within our own country. NSA, assisting the NSA in spying, whether it was in Toronto or in Ontario for the G8 and the G20 summits. And we also know that at times Canada has played a lead role in different kinds of surveillance experiments. And so the Wi-Fi tracking experiment, there's Ron Diebert from the University of Toronto talking about it, was one of the first to gain a fair amount of attention. This being an attempt to try to track where passengers went after they left the airport by first using an airport Wi-Fi network to track the device, and then use try to track those same devices as they moved around to see if they could identify patterns of where people moved within the community once they went outside the airport. And of course, using airport Wi-Fi, especially now that they're always free, is one of the first things that you often do if you've got a few minutes in the airport. And to think that these sorts of activities are actively tracked as part of experimentations, I think took some by surprise. Perhaps even more, the revelations of tracking, and this again, a CSE program, tracking millions of downloads daily. And so they looked at these websites that allow people to upload and then download various kinds of content, cloud-based storage effectively. And the NSA or the CSE, together with others, tracking hundreds of millions of downloads every month. And so they're able to track all of this, and it's notable here that the tracking, of course, takes place not because any of these websites were handing over their server logs to law enforcement, but rather because they are able to track the transmission side. So it's not as if you have to reside on the server if you are able to surveil the network itself and identify what activities are taking place. Emails to the government, oftentimes encouraging people to speak out to the government and to know that those emails are actively being tracked, was yet another revelation. And perhaps the place where that highlights some of the challenges between security versus security, the revelations that spy agencies such as the CSE and NSA were well aware of bugs located within some of the most popular app programs. So in one instance, a browser used by hundreds of millions of people, particularly in Asia, that have vulnerabilities. And rather than using that information to patch the vulnerability, to try to make people's use of their devices more secure, this was viewed by signals intelligence agencies as an opportunity to better access information itself. And that question of security versus security, the national security on the one hand, but the personal security, in this case of hundreds of millions of people, is, I think, a theme that we are starting to see replicated again and again with, in many instances, no real easy answers. So as I said, the question from my perspective, wearing a policy hat living in Ottawa, is within this environment and within a new government, now what? Well, the easy answer, of course, is and will be oversight. And in fact, we have already had the Liberal government indicate that better oversight in the context of parliamentarians providing some sort of committee of oversight is part of what will happen. We've had many, the former Privacy Commissioner of Ontario, the opposition parties, and indeed some private members' bills that have all focused on this issue, arguing that the solution, or at least part of the solution, is to ensure that members of parliament play an active oversight role when we think about what takes place at CSE and CSIS. And while I don't think anybody is against, well, there actually were some against oversight, the last government, by and large, many that examine the issue wholeheartedly agree that you certainly can't go wrong with more oversight. But I think one of the things that we have started to learn is that it can't just be about oversight. First off, anyone who takes the time to watch Question Period and see the way our MPs sometimes conduct themselves, I think can have little faith in the notion that they are somehow now going to solve all our oversight problems once they step into a room such as this, perhaps with the doors closed, and they're going to provide the oversight that and the kind of assurances to the public that has to date been lacking. But oversight without addressing some of the core fundamental questions that exist within the law today runs the risk of simply providing another layer of review over a system that many would argue is broken already. And review of a broken system still leaves a broken system. Now, what are the kinds of issues that I think one would hope will become part of the discourse and discussion in an environment when the government has said that they are open to that broader discussion? They aren't solely about trying to fix C-51, but rather are encouraging and will encourage people to engage in a more holistic, broad-based review of some of these questions. Well, certainly at the very top of the list, I think, is the issue of metadata. An issue that I think is enormously underrated, certainly by politicians, perhaps sometimes intentionally, when it's raised, this notion of a difference between the sensitivity and the privacy implications of content on the one side and the metadata, the data about data, the so-called digital exhaust that is at times generated that describes our location, who we communicate with, and the other, and the suggestion that somehow that information carries a lower threshold in terms of the privacy implications is, I think, a notion from a bygone era. It may have been the case at one point in time before the sorts of data analytics that we've been talking about, the data collection possibilities that we've been talking about, that kind of data didn't have that same import. That may have been true at one point in time. It is surely no longer the case today. Now, we have had successive CSE commissioners raise concerns around access to metadata, and yet fundamentally we have yet to see any sort of change in the law. Indeed, we even now know that there has been a breach involving access to metadata, and the government's put a stop to some of that sharing with some of our Five Eyes partners, and yet I think rather stunningly, the government says they cannot disclose who has been affected or the degree to which they have been affected for fear of infringing or violating their privacy. A certain irony in that, but certainly raising real questions about the scope of the program, the collection of metadata, and a status of the law that somehow suggests that the privacy implications of this information widely collected is somehow less than content, which everyone can readily understand the privacy implications of. We also unquestionably, I think, face real questions from a jurisdictional perspective. And so I was having an earlier discussion with someone at the break about what Andrew Clement at the University of Toronto describes as the boomerang effect. A desire in many instances to try to keep data within Canada and ensure that it at least is entitled to and receives Canadian-based privacy protections. And yes, yet our network today is largely an integrated internet network that is at least Canada and the US, if not North America wide. And so for some of the largest providers, including Bell, they exchange with other ISPs outside of the jurisdiction, meaning that once you communicate with others, your data transfers outside of the jurisdiction and back again. And if we think about the example of the data downloads, the fact that what it matters isn't necessarily what takes place on a server, but rather what the activities and the transmissions that take place on the network, the ability to track that information, I think, is significant. If we ensure that there are Canadian-based protections, we still run into questions about whether or not our laws are up to the challenge. And we have seen, I think, regular concerns on the PIPEDA side, private sector privacy legislation, or the provincial equivalents, where we know now that telecommunications companies have been actively working with law enforcement, providing information on subscribers in well over 1 million times per year, much of this without any sort of court oversight. And we've got now layer on to that, the Supreme Court of Canada in Spencer arguing that this is information that enjoys a reasonable expectation of privacy, and yet how we operationalize that in an effective way, I think, still remains to be seen. Just last week, we had the Privacy Commissioner of Canada focus on the other side of privacy legislation, that being the Privacy Act, what happens when our government protects the information. He becomes yet another privacy commissioner, federal privacy commissioner, excuse me. Indeed, every single privacy commissioner since the enactment of the Privacy Act has made it one of their top priorities to argue that this legislation is now woefully out of date. They were literally saying that in the 1980s. They still say it now today. And yet the government has been willing at times to increase the level of protection, or at least make changes to what they obligate on the private sector, or they oblige the private sector to do, but have been unwilling to take on those same kinds of obligations and adopt those same kinds of standards when it comes to what the government can do with our personal information. Now, it's not just Canadian protections, it's US protections as well. This is a piece I wrote together with a number of other scholars a little while ago in the National Post that talked about what happens when data enters into the United States and the imbalance in terms of protections. And so that those in the United States, if you're a US citizen, enjoy a certain level of constitutional protections. If you are from outside the jurisdiction, though your data is in the United States, your data enjoys a lesser standard of protection. In Europe, that has now come to be seen as a major and significant issue coming out of the Max Schrems case. There's Max right there, which of course has now led to discussions to shift from the safe harbor to the privacy shield, where the US is undertaking to try to provide greater protection. And in fact, there have been some attempts now, even within the US Congress, to talk about how to provide foreigners with stronger privacy rights, as this threatens to become a significant trade issue, if nothing else, with increasing concerns about the effectiveness of an adequacy of privacy protection once data enters into the United States. And finally, as I alluded to off the top, perhaps one of the biggest battles of all is one that will take place on the technology plane, that being over encryption. We saw this particularly coming out of the Paris attacks, although as John Oliver, I think, rightly noted, this dates back to the Clipper chip in the 1990s. We are seeing the same debates over the ability for government to gain access to encrypted data that have been ongoing now literally for decades. It started, let's say, after the Paris attacks, where there was talk about the attackers using encryption. Everybody uses encryption. They did too. It turned out that some of the allegations that were even made in this New York Times article were unfounded, and the Times quietly pulled back on the article. But as I mentioned, it's the Apple case that crystallizes this in a way that is understandable to hundreds of millions of people who have those devices in their pocket right now and have real questions about who can gain access to their information at a time, as we've seen, where the network itself may be surveilled, where the internet companies themselves are mining the data for any number of purposes, where the telecommunications companies are being asked for the information in Canada over 1 million times per year. In certain respects, it appears that the device manufacturers may be the last line of attack, or last line of safety, I suppose, when it comes from the perspective of the user, although it turns out that it's, if one compares the level of encryption on Android phones compared to iPhones, you find that far more usage of encryption on iPhones than you find in a closed environment than you find, at least for now, on Androids. And so all of this as part of this broader policy debate, one that implicates certainly those questions around the privacy security balance that I think we've become accustomed to for some time, but I'd argue goes even further today, one in which we often now have to debate security versus security, where the choices are not just about whether or not we give up some privacy for security, but whether or not we sometimes as individuals give up some personal security in our devices or otherwise in return for broader national security goals, and how we strike some of that balance. Thanks very much for your attention.